We have a general rule that says that you can't really get compensated for business losses. Why not? Well, I hear it all the time. It's not something that you can really prove. It's speculative. And the Mitchell case here was basically a farm. And my understanding of it, reading it, was that that business was put out of business. And the owner was not allowed to recover the business loss. Why? The theory behind it is that only your real estate is being taken, and you can relocate that real estate somewhere else and be gainfully employed and have your business operate in location number 2 when location number 1 is taken. But I've had a couple of occasions, even before the case that I'm going to talk about in just a few moments, where we couldn't relocate. One of them in particular was it was a diner in the city of Jersey City, a block off of the Hudson River, next to a PATH commuter rail station. And the diner was open 365 days a year, 24 hours a day. And if that diner moved 2 blocks away, it would not be able to replace the business that was lost being across the street from a 24/7, 365 commuter location in the most densely populated part of our country. So it didn't matter whether the diner property was worth $5 million in that location and one 3 blocks away was worth 3. That owner would not be fairly compensated and made whole unless he or she could have received the damages that would be suffered by the business, because there wasn't any more property available in that location to relocate the diner to. In that case, we obtained a political result to stop the taking, because we knew we could not make the owner whole. And we were fortunate to do that. But unless you luck out, your clients are at risk of losing something very valuable that, as a matter of course, I've heard this from a variety of speakers, some of whom are very good, close friends and colleagues, that there's this category of damages that are recognized as being non-compensable. Well, if they're damages and you can prove them, why aren't they compensable? Why should there be such a thing as non-compensable damages when the goal of the Constitution and the law that interprets it is to make you whole? If you're damaged, you should receive compensation for those damages. There should be nothing called non-compensable damages unless you can't prove it. Your legislature can legislate this in, and some states do it a little bit. Because the legislature has the ability to offer more than the Constitution provides. Not less than it guarantees, but more than it provides. But the Joslin case that's up here actually calls to that issue. It says, in the express absence of a statute allowing it, the injury to a business is non-compensable. So where do we go? And how do you analyze this, knowing that the goal of the Constitution is not necessarily fulfilled by the reality of where most of us have gone over the course of these cases in our careers? As I indicated before, compensation is not generally defined to include losses to the loss of a business because of the ability to relocate. But if that's really the law and you can prove that you can't relocate, then is the compensation fair and just? I would argue that it's not. Another reason why business losses are not generally allowed is because of that other buzzword that we hear all the time. It's too speculative. Okay, those kinds of things are too difficult to prove. Well, in my former career as a general practice lawyer, I used to try commercial litigation cases where we tried business loss issues all the time. And if you couldn't prove it, you didn't get it. But if you could, you got it. Well, why should we be any different? We have a Constitution saying that we're supposed to be able to be made whole. So I don't buy this speculative issue, except for the fact that I have to, because every other decision that I read about it talks about it being speculative in an eminent domain context, even though the same court might allow it in another commercial context. I think it should be the other way around. So what we do have is we have a little window, and that window is mainly created, at least in my experience, by one case, which was decided in the 1940s by the United States Supreme Court. It's called Kimball Laundrie. If you don't know it, you should read it. Kimball Laundry was a case where the federal government took over essentially a commercial laundromat during the war and put the operator out of business. And what the court focused on there was the agreement and concession that the business could not be relocated. They took it over. The government took the business, not just the property, and for that reason, this was a temporary taking where they were going to get it back. For that reason, they were allowed to recover their business loss because they couldn't relocate because they were going to get it back.